Hi, Alecia Hall, Florida estate planning, probate attorney, and realtor. If this is your first time visiting my channel, welcome. Please don't forget to like and subscribe so that you will be notified as soon as I upload new videos about estate planning, probate, or real estate. In today's video, I'm going to outline the Florida probate process from start to finish. Probate is the court-supervised process of administering a person's estate after they have passed away. It consists of admitting a will to probate if there is a will, appointing a personal representative, this is done by the judge, marshaling the assets of the individual who has passed away, paying off any debts, and finally distributing assets to the beneficiaries of the estate. In Florida, the probate case is filed in the county in which the person lived when they passed away. The first step in opening a probate in the state of Florida is filing an original short form death certificate as well as the original last will and testament if there is one. The short form death certificate does not include the cause of death. That's different from the long form, which does have a section titled cause of death. Because someone's cause of death is not public record immediately, we are not allowed to file the long form death certificate in the probate court. It has to be the version that is a short form without cause of death. If you do not have a will or you do not have the original will, there is a different process that has to be followed in the probate case. If the original will cannot be located, then the state law presumes that the testator, that is the person who signed the will, intended to either revoke or destroy that will. It's done by an evidentiary proceeding where we bring in witnesses who are able to testify that this person never changed their wishes, they never changed their will. I've known Auntie May for my entire life, and Auntie May always said that she was going to leave this house to this cousin. And I knew that it was in her will because I remember when she went and got the will signed and she never ever said anything about changing her plans. And so that's the kind of testimony that we would have to bring into the court to overcome that presumption that the will was destroyed or revoked. If someone does not have a will, then they have died intestate. You can watch this video to learn about intestate succession in the state of Florida. In other words, what happens to your assets? How will they be distributed if you die without a will in the state of Florida? In the case of a person who dies intestate or without a will, we're going to also have to file an affidavit of heirs. The affidavit of heirs is a family tree where we have to list for the court the names of various family members, their addresses, if known, as well as dates of death, if applicable. For some people in the family tree, we may also have to provide their death certificates. Once we have gone through the process of filing the death certificate and any wills and any affidavit of heirs, we also have to file a petition for administration with the court. And this outlines who passed away, when they passed away, where they were a resident of. We include a list of their assets as we know them and their estimated valuation. We also will identify potential beneficiaries. If there's a will, we name the beneficiaries. If there was no will, we name the heirs at law. The petitioner who is filing the petition will also have to explain to the court what their relationship is to the person who has passed away. In addition, the petitioner must also submit an oath with the court. In the oath, the petitioner must swear that they meet certain eligibility criteria in order to serve in capacity as a personal representative. In the oath, the petitioner must state that they meet the eligibility criteria in order to serve as a personal representative in the state of Florida. There is a statute that outlines the requirements of a personal representative. First and foremost, they must be 18 years old or older. Second, they must state that they have never been convicted of a felony. Third, and this is new, this is as of November 4th, 2021, they must state, I have not been convicted in any state or foreign jurisdiction of abuse, neglect, or exploitation of an elderly person or a disabled adult. They must also state that they are mentally and physically capable of carrying out the duties of a personal representative. And finally, they must be either a Florida resident, or if they are not a Florida resident, they must meet one of the following three criteria. The first one is they are either legally adopted child or adoptive parent of the person who has passed away. Number two, related by lineal consanguinity, which means they are either a descendant, so child, grandchild, great-grandchild, or parent, grandparent, great-grandparent of that individual, a spouse or a brother, sister, uncle, aunt, nephew, niece of decedent, or someone related by lineal consanguinity of such person, so of any of those people that I just outlined specifically. And the third option, if you are not a Florida resident, is you are married to, you are a spouse of one of the otherwise qualified people that we've listed in options 1 or 2. The person who is asking the court to appoint them as the personal representative of the estate must also indicate and affirm that they will faithfully administer the estate in accordance with Florida law. The final thing that is outlined in the oath is they have to appoint someone as their registered agent. This is typically going to be the attorney that they have retained to handle the case. In Florida, you have to have an attorney represent you if you are filing a probate, unless it is a small probate estate. We don't handle small probate estates. They're very de minimis, and you can actually obtain the packet for a small probate estate directly from the county clerk's office. So once you have filed the petition and the oath and the supporting documents, you're also going to submit a request to ask the judge to enter the order. The judge might require that a bond is posted, and if they do, what's going to happen is they will enter an order appointing so-and-so as the personal representative, and in the order they will state that the person has to first post a bond in a specific amount. If there is bond language in the order, then the individual is going to have to reach out to a surety and bond company. They're going to have to acquire the bond, and then we submit proof to the court of the fact that the bond has been issued. And once we submit that proof to the judge, we ask them to issue the letters of administration. Letters of administration are not actually letters. They are court orders issued during the probate case to authorize the personal representative to begin the process of administering the estate. It basically serves as proof to the world that this person has been appointed as the administrator. And that's very important because in order to begin communicating with some of the financial institutions or whomever may hold assets of the decedent, they're going to need a certified copy of those letters. And the judge will not issue those letters until we go through all of the steps to open up the probate properly and initiate the proceedings and show the judge that this individual is entitled to serve as personal representative, they are capable of serving as personal representative, and if there are any people who have a superior right or interest in serving as personal representative, we have to name those individuals. And if necessary, depending on whether those people will consent to the appointment of this individual, then we have to actually provide them with notice and wait for a specified period of time for them to object if they wanted to. Once we have a personal representative identified, the next step is to file a notice to creditors. What this does is it begins the clock running on the statute of limitations for creditors to file their claim. Yes, creditors do still have claims against the estate after you pass away. So what we do is we serve the notice to creditors on any known or ascertainable creditors. These are creditors that we reasonably should know exist. So for example, if you're seeing letters from Chase Bank and Bank of America and whomever else coming to the house, you know that these are known creditors of the decedent, and so we have to make sure that we send them notice. The notice to creditors is sent by certified mail return receipt requested or any other method that provides for a signature upon delivery. Once you send the notice to creditors to those known creditors, they now have a 30-day period to respond and file a claim in the probate case. If they do not file their claim within those 30 days, their claim is barred. For other creditors, so creditors that we don't know exist, we're going to publish a notice to creditors in a local newspaper. It is actually the exact same notice to creditors, it's just going to be published. And for those creditors, they have a 90-day period to file their claim in the court. We start counting the 90 days from the first date of publication. The publication is actually going to be run on 2 consecutive weeks, but we count from the first day, and that's 90 days. If they don't file their claim within those 90 days, again, they are also time barred. What happens if there is a creditor that you most certainly should have known existed and you fail to give them that 30-day notice? In that instance, they have the full period of 2 years within which to file a claim. Now understand that by those 2 years, you could very well have been done with your probate case. Everyone could have received their money and we're all just minding our business, spending our inheritance. This is why it's extremely important that when you start a probate, if you have a family member that you are opening probate on behalf of, It's very important that you provide the attorney with any and all known creditors, because this could be the difference between 30 days and 2 years for that creditor to come out of the woodwork and ask for their money. Once we have all known creditors, sometimes they will file claims and we deal with those claims as needed. There is a hierarchy of how claims are to be paid by the estate. If there aren't sufficient funds in the estate, then there's nothing to pay out. But if there are funds, you may have to divide it among different classes of creditors. In Florida, we have 8 different classes of creditors in a probate case. The first class, it's called Class 1, is costs, expenses of administration, compensation of personal representatives, and attorneys of the estate. Class 2 consists of reasonable funeral, interment, and grave marker expenses, whether paid by the guardian, the personal representative, or any other person, not to exceed the aggregate of $6,000. So you have a $6,000 cap on all of those funeral, end-of-life related expenses. Class 3 of creditors consists of debts and taxes with preference for claims in favor of the state for unpaid taxes, court costs, fees, or fines. Class 4 are your reasonable and necessary medical expenses and hospital expenses incurred within the last 60 days of someone's life. So this is just really making sure that clinics and hospitals aren't declining to care for someone towards the end of their life. So when they're really seriously ill, simply because they don't think they'll get paid, they now have a pretty high level of priority in the class of claims here in Florida. Class 5 consists of family allowance where necessary. Class 6 is any arrearage from court-ordered child support. Class 7 consists of debts acquired after death by the continuation of decedent's business. By the way, if I haven't defined it before, decedent is the person who has passed away. Those debts are only to the extent of the assets of that business. And finally, Class 8 consists of all other claims. So this would include those founded on judgments or decrees rendered against the decedent during their lifetime, and any excess over the sums allowed in paragraphs B and D. So remember, there was that $6,000 aggregate of funeral expenses. Well, if let's say they spent $8,000, this is where that other $2,000 would be. So only the first $6,000 goes under your Class 2 claims. So if there are no funds remaining after the preceding class is paid, then the next class that is out to be paid, they're going to receive a payout, but it's going to be based on the proportion of their estate claim. So it's a pro rata share based on how much they are claiming they're entitled to. Once the creditor periods have expired, so that 90-day period is going to be your longest one, and we've dealt with any creditor claims either by paying them, negotiating settlements of an amount less than, or getting rid of it completely because there are no funds available to pay them out, dealing with any late filed claims, so you want to strike any claims that are filed late, selling, liquidating any assets that are not going to be transferred to beneficiaries outright. So if there is a house and we're not going to sell it because the will left that home to so-and-so, you might need a deed depending on what kind of property it is. If it is the homestead in the state of Florida, we're going to actually have an order. We file a petition with the court asking the judge to declare that home as the homestead. What that means is the homestead is exempt from the creditor's claim. So all those creditors' claims, the house is not going to be factored into determining whether there are assets to pay off the creditors. As long as it is determined that this house is homestead, it is going to be transferred by virtue of an order determining homestead status that's going to be entered by the judge. So the creditor period has expired, or we've dealt with the creditors depending on where they fall, whether there are sufficient assets to pay. We have our homestead order in place, identifying that this particular asset is homestead, it's protected, and it now is owned by so-and-so. We're going to name who they are. We have the judge name who the new owners are of that homestead property. If there were any exempt properties involved, we also will have obtained an order from the court determining those particular assets as exempt. In Florida, you're entitled to up to $20,000 value of household furnishings, as well as 2 personal vehicles. There is a weight restriction on that, but it cannot be business vehicles. It has to be personal vehicles, and you get 2 of those that are exempt. Those get transferred as well. The personal representative is required to file a signed inventory with the court within 60 days of them being appointed as personal representative. This inventory is very important because all of the beneficiaries are going to know exactly what kind of assets we're dealing with. The inventory, although it's filed with the court, it is not public record. The process of closing the estate begins with filing a final accounting. The final accounting is literally what it sounds like. You are going to, again, restate what the assets of the estate were. If anything was liquidated, you're going to also indicate this was sold, blah, blah, blah. You're going to itemize the amount of compensation that has been paid to the attorney, the personal representative, and any other professionals that have been retained by the personal representative on behalf of the estate. Some estates may need a professional appraiser to determine the valuation of certain assets. You might need a CPA to assist with certain taxes that have to be filed. You may actually need to bring in someone to value a business. These are all people that have to be compensated in some way, and you have to let the court know how those people have been compensated. In the final accounting, you will also list any and all creditors that have been paid out of the estate funds. You will submit a plan and petition of distribution, and so this is also going to list how much is going to be paid or what is going to be distributed to the individual beneficiaries or heirs at law. Now, if you don't have consents from the people involved, then you're going to have to serve that, and they have a set period of time within which they have to object. If they don't object, then you're free to move forward, but they have to have that right of objecting. It's important. We do not make those distributions to the beneficiaries or heirs at law until they have either waived the accounting, consented to the accounting, or they have received notice and 30 days. That's the period that they have to object. So once the 30-day period expires, then we can go ahead and we can start distributing the assets. When we send those distributions to the beneficiaries, if they aren't going to come to the attorney's office to pick up their check, then what we do is we include a copy of a receipt and ask them to sign it. In general, most people will go ahead and sign the receipt, but I have had situations where people don't sign that receipt, and it's okay. I am able to use the cashed check as proof that they have accepted their distribution, because remember, they didn't object within those 30 days, and now they've received their payment and they haven't objected again, and they cashed that payment. We can show the court, look, they basically consented. If no one objects to the plan for distribution, then I don't need an order of distribution. We're good to go at that point. And what I can do at this point is really wrap up the estate by filing a petition for discharge. That petition for discharge is telling the court, look, we have administered the estate, we've paid all qualifying debts, we've distributed the assets to the beneficiaries or heirs at law, and judge, we are simply waiting for you to enter an order closing out the estate and relieving the personal representative of their obligations and liabilities under this probate case. Now that is the probate process in the state of Florida from start to finish. I definitely skipped over some of the nuances to make it a little bit more easy to understand, but in a nutshell, that's what probate looks like here in the state of Florida. If you have recently lost a loved one who was a resident of Florida or died having assets in the state of Florida and you need assistance with the probate, please feel free to click on the link below to schedule your free probate consultation.